Okay, good evening and welcome to our presentation on estate planning. For those of you who don't know me, I am Jeff Hare with Aventus Advisors. Aventus is a financial planning and investment management firm with clients in 15 states. And that was sort of the need for the recording tonight, is we wanted to make sure we were capturing this for people that were out of town. Our featured expert today is Kristen Forbes. Kristen is the managing partner at the Forbes law firm in Davidson, and she specializes in estate planning and estate administration. Estate administration is a great thing to do if you're in estate planning, because you get to see what happens when you get to the administration point, and it really helps you make sure you're setting things up correctly in the process. So her background is really important for estate planning. I think it is important to start with a good financial plan when looking to create an estate plan. I hope Kristen would agree. I'll review a few of the components of a comprehensive financial plan briefly before turning it over to Kristen. So developing a comprehensive financial plan really starts with organizing your assets. We find with a lot of our clients that we're working with, just getting them to think about what they have, where it is, and how to get it organized is a great starting point. If you need any help from us, certainly let us know. I think most of the folks in the room here have been clients for a while. Hopefully we've helped you get organized. If there's anything that we could help you with, additionally, let us know. The next step really in the financial planning process is establishing long-term and short-term goals. Goals can be a lot of different things. One of the big things that people start thinking about typically in their 40s and 50s is retirement. When do I want to retire? How am I going to retire? What's that going to look like? You may also be thinking about education and how to save for your kids' education, for college, things like that. Once we've gotten through kind of a retirement strategy and an education planning strategy, having a long-term investment plan is obviously a key component of a good financial plan. And that will include things like how to figure out how to reduce taxes. Taxes can be reduced through contributions to different types of accounts like 401ks for business owners, IRAs, Roth IRAs, and things like that. Part of the plan is also to look at insurance needs. The biggest need for insurance, in our opinion, is really for income replacement. So if something was happen to you, would there still be income there to support your family? Long-term care is also an important issue to think about as well. I see Paul here tonight. Where is Paul? Paul's wife, Susan, is active in the long-term care business and would love to talk to anyone about long-term care in particular if there's some interest there. And then when we get to kind of retirement, then we also need to think about a distribution strategy. And what does that mean? That means, where do we take money from that is tax effective and allows us to kind of live a good quality life through retirement. And then finally, the last point I'll bring up is having a good estate plan, because like taxes, the other thing that's inevitable is life is we will pass on. And when we do that, we want to make sure we're well organized and we're able to pass on our assets in the way we want to and in a tax effective manner. So with that, I'll turn it over to Kristen.
Thank you, Jeff. Thank you all for coming. So as Jeff mentioned, we have estate planning, which is pre-death. We get everything in order, and then hopefully after the death, it's a very easy process so that those left behind are not burdened with a really difficult and lengthy process to get everything where it needs to go. So who needs a will or who needs an estate plan? Everyone. Some are more sophisticated than others. Some can be very basic, but the 24-year-old new college graduate who has a car and a couple $1,000s in the bank needs a will, needs powers of attorney. The 35-year-old couple with young kids, they certainly need to have the same documents. As we continue to age, we all do. And why? It gives you a say in what happens. If you don't have these documents in place while you're still alive, for the powers of attorney, for financial reasons or for healthcare reasons, someone else is going to make those decisions, and it might not be whom you'd like to have make them. Additionally, after you pass away or while you're still here, conflicts between family members and a smooth transition of assets, this helps to reduce those conflicts, and then as I've said, gets everything more easily where it needs to go. Also reduces the cost of your estate administration. If we can get things structured in a way, for example, a trust, as we'll talk about, if we get things into a trust and they bypass probate, which saves cost. As well as, again, I just can't stress how easy it makes it, as Jeff mentioned, the administration end of it, that post-death end of it, when the documents are in order the way you want them to be, it makes a huge difference. If you don't, a probate judge gets a big say in what happens, how your assets are divided, who becomes the guardian of your children, who probates your estate. Could be people you don't want to, could be people you don't even know. One of the common things that I think people think, if you're married and you don't have a will, everything just goes to the spouse, but it doesn't. So a third of your house could go to your spouse if you have 2 kids, and then your minor children get the other 2/3. Those are things that people don't realize. Assets can be distributed to your children before they're ready. If you don't have a will in place, if you have minor children, at whatever part they inherit, like I said, if you've got a spouse and 2 young kids, they're going to get 2/3 of your assets. And then at 18, they just get whatever it is. So a court-appointed guardian is in place until they're 18, and then it's just theirs, free and clear. So if you had retirement accounts, whatever assets you had in the bank, your home, all goes to the kids at 18. A loss of privacy. The probate process is public. Anyone can walk down to the courthouse, go up to the file room, pull out the file and see who your beneficiaries are, what assets you had, and where they're going. Family member disputes. If you have this plan in place, it's clearly saying, these are my assets and this is what I would like to see happen to them. If you don't have this in place, that's not how it's going to happen. So what is probate? It's the transfer of assets and dealing with creditors after someone's gone. We ideally would not have many assets go through probate, but the big benefit will be to head off creditors. So if there are any creditors, opening that process gives them a period of time to make the claim and then determine what's going to happen with that claim. What assets go through probate? Non-probate assets are things that are held jointly, so joint with rights of survivorship. Often a couple would own their checking account together, own their home together. Those things bypass probate. Anything with a beneficiary designation, IRA accounts, retirement accounts, life insurance, life estates, something that people often would grant in real estate, and then assets owned by a trust. So if you have assets in a revocable trust or even an irrevocable trust, they bypass probate. So what is that process? The first step is we present a will if someone had one, or we say that they didn't. We get someone appointed to be the personal representative, so it's going to be the executor or administrator of the estate. We're going to inventory and gather all of the assets, give a notice to creditors and all of the heirs and whatever beneficiaries might be named, pay any income or estate taxes, handle the debts, how best they can be handled with the assets that'll go through the estate, make distributions to the beneficiaries, and close the estate. That makes it sound pretty simple. Actually, when you're in it, it can be. It can be a really easy process. If the documents are in order, it also can be a huge mess. So why to avoid it? Because it can be such a huge mess, as well as the cost, as well as it being public, and how long it can take to complete. It can take 6 to 9 months. It can take longer than that. I've had estates that were in 12 to 15 months to try to settle the assets. So back to the pre-death planning, since we want to try to avoid probate or make it as simple as possible. What does an estate plan include? These are the documents on the left that it can include: a will, a durable power of attorney, an advanced healthcare directive, a HIPAA form. Those are all documents that everyone should have. A revocable trust, there are situations where it's appropriate. Sometimes in the will, we can have just a testamentary trust, a trust that's embedded in the will. Sometimes a trust isn't appropriate in the situation at all. A certification of trust is a way to keep your trust private. Nobody has to know what's in your trust. It's between you and the trustee and then whatever the beneficiaries receive. So the certification of trust is something you can provide to financial institutions to say, I have this trust in place, and here's all the information that you need to know, but you don't need to know my specific provisions that are in there. A statement of disposition of tangible personal property, that's something I always advise my clients to keep a handwritten list. We'll keep it with the documents that we draft. And it's a handwritten list that says, I want this necklace to go to my daughter, and I'd like this dresser to go to my son. Handwritten because those who come behind you tend to follow it. If you've taken the time to sit down and handwrite it, they tend to follow what you said. It doesn't make it legally binding. That's what we tend to see happen though. In the plan, or as part of drafting the plan, we'll handle the retitling of assets, making sure the beneficiary designations are up to date. Guardianship designations, we'll put that in the will. For minor children in North Carolina, we do put that in the will. However, it's not legally binding. So if you named someone that at the point in time you named him or her or them, everything was in great shape and they were doing well. However, years later when you pass away and your children are still minors and they're now a mess, they're a drug addict or something very unexpected has happened, the court is not going to allow the child to go to them. So even though we've put it in the will, it's not always going to be followed, but if everybody is in good shape at will, if it's in the best interest of the child, that's the standard that we use, best interest of the child. And then also life insurance or an irrevocable trust. Life insurance, as Jeff said, can be used for income replacement or almost estate creation. Where there is no will, we don't have beneficiaries named, we don't have a guardian named for minor children, we don't have a personal representative. And I have an example that I'll give you a little bit later that almost encompasses everything that can go wrong with an estate. But you don't get to choose who your personal representative is. So someone you might not want is who's going to come in and get all of your assets together and then distribute them to your heirs. And then there's no testamentary trust. Where I use those the most is when there are minor children involved and maybe we don't have the assets necessary for an actual revocables trust. We'll put a testamentary trust in the will that just limits when the kids can get the funds. So a trustee can provide them what they need up until they reach certain ages, maybe 30, 35, and 40, and then they can get larger sums. So the legislature's who decides. If you don't have these in place, these are going to be the problems, and it's whatever statutes we have in place that will guide where everything ends up. So as I mentioned a little while ago about if you have a spouse, people commonly think, well, then my spouse will just get everything, but they don't. It'll be split with your children. If you have a spouse and you don't have children, then it'll be split with your spouse and your parents. It's never going to be the spouse who gets everything. Maybe if you have everything joint, but for the most part, it's not going to be the spouse if you don't have a will. So let's talk about a will. It directs your assets. It directs where they need to go. It pays any debts. It pays your taxes, what other expenses, such as funeral bills. It's where you're going to name that personal representative, executor, administrator of your estate. It's where you're going to name the guardian. You're going to direct where your assets go, including your tangible personal property. So the stuff that's in your home, as well as what happens to your accounts. And as I mentioned a minute ago, the testamentary. The guardians. So those are going to be for minor children or incapacitated children. It's one of the most important reasons to have an estate plan if there are minor children involved. It's so important for a court to know whom you'd like to have them. You could have a lot of people in your life that on paper look like they would be a good fit, and if no one knows who you would prefer them to be with, then that might not be where they end up. As I mentioned, as it says, the court will look to statute. It's the best interest of the child. That's what the court will look to. So a revocable trust or a living trust. What does it do? So it centralizes your assets to be managed during your life and after your death. So think of it like a bucket, and we can put everything in it. And while you're alive, it's still your social security number. Doesn't really feel any different to you. All of your assets still operate the same. Some of your bank statements will come with a different titling. That's really all that you'll feel during your life. However, when you pass away, for that trustee who comes behind you, so commonly a couple would name each other, or maybe you'd name an adult child. For that person who comes behind you, they already have all of those assets in the bucket. Where with that will, They still have to gather everything, inventory it, show it to the state, and then take that time frame, that 6 to 9, maybe even 12 to 15 month time frame to get everything out to where it needs to go. With the trust, it can all happen right away. Those provisions of the trust go into place right away. So as I sort of was just hitting on, it's extremely flexible. You avoid probate, so whatever's in the trust can go ahead and be distributed right away. Protection for vulnerable beneficiaries, so for minors or anyone with special needs, we can embed right in a revocable trust a special needs trust. So if there's someone who's maybe receiving public benefits, we can put language in there that says we want to help them with this trust. However, we don't want to do anything that would interrupt the benefits. So it would keep everything in place for them as well as provide them anything extra that they need. Also, you can provide for any charitable intentions in the trust. And again, those can all be then paid out right away. It does not provide asset protection for the grantor. So you can't put things into a revocable trust and then have creditors be unable to touch them. While you're alive, anything you've put into that trust is still accessible by creditors. It also can't protect against long-term care costs. So if that's a concern as part of your financial plan with Jeff, either have that covered from your assets or purchase long-term care insurance. And it doesn't affect the income taxes. So as I mentioned a few minutes ago, the Social Security, your Social Security number is the tax ID for the trust while you're alive. Your income taxes look the same. Nothing changes other than the titling on some of your accounts while you're alive. Use a pour over will to get anything that isn't in the trust before you die into the trust. So sort of just pours anything into the trust that wasn't already in that bucket. Anybody have any questions right now?
I have a question, Kristen. You had mentioned that there's some pretty good potential savings avoiding probate, a lot of those assets. A lot of times the probate court will charge a percentage of the assets that aren't in the trust going through probate.
Right, yep, several $1,000s typically. I just actually was at the courthouse the other day and it was around $3,000 and I think we had about $300,000 going through. And that's just a fee paid to the court. So that's just gone. So a will versus a revocable trust. A revocable trust avoids probate, as I've already said. Will is what we use to cut off any creditor claims. We don't want any claims coming up down the road, whether it be medical claims, unsecured debt, a car loan coming up down the road. So if we open an estate, we just cut that off. A will or trust both can reduce or avoid estate taxes. Right now, our estate tax exemption is pretty high, so most of us don't have to be concerned about it. It's $11.8 million for an individual, over $23 million for a couple. However, that will sunset in 2025, so it will reduce significantly, likely in 2026. The trust, orderly administration of property prior to death. You have, again, everything in the bucket. It's very organized and easy to deal with. Protecting for minors or spendthrifts or special needs situations, both the will and a trust can provide for that. The trust is private. Again, that will is public, and whatever goes through that estate, anyone can go down and see at the courthouse. Expense prior to death. The trust does have expense prior to death just because you have the drafting. Expenses after death, though, you don't have any of the estate expenses, so the potentially thousands of dollars that can be paid just simply in a fee to the court, you don't have. However, expenses after death with the will, you do. Immediate and continuous access to cash flow. That's one of the huge things with a trust, that there's no interruption. So when you pass away, if you don't have a trust in place and it's just a will, everything is frozen until it's sorted out. The creditor claims have, the 90-day period for creditor claims have passed. And then you can begin to pay those debts as well as pay out to beneficiaries. For the trust, you have the avoidance of a will contest, so you don't have that risk of people coming forward saying, oh, they intended to include me and they didn't. So I'd like to challenge this will. With the trust, it's all private and just goes out to the beneficiaries and no one can challenge that. So in a trust, who is commonly named as a trustee? While you're alive, typically it's you. while you're alive and have capacity. If you lack capacity or once you pass away, you're going to have someone else step in. Commonly, it is family members, so a spouse or adult children. You can name friends, you can name professionals. Obviously, there are fees. If you do professionals or institutions, there are fees involved. Probably up to the first $1 million and be around $4,000 a year would be an average fee. You could have beneficiaries be trustees. So maybe it's a couple and then we have one who's passed away. Well, that second one is alive or until they pass away. You could have the beneficiaries be the trustees. So you have adult children, maybe it's one of them that you name. Or you could have guardians as trustees. So if you're going to have a guardian that you'll name for minor children or grandchildren, then you'll have the guardian also handle the money. Some people go both ways on that. They like to have the guardian handle the money. Sometimes they want to have someone else handle the money and the guardian handle the children. Beneficiaries, I think I've hit on this, but children, spouses, siblings, parents, charities, that's typically who will be the beneficiaries of trusts. Is it funded? It's really only going to do what you want it to do if it's funded. What that means is you have to get the assets into the bucket. If you don't, they're going to pass through that pour over will, and then it's all public. So you don't have the benefit of reducing the estate taxes or the benefit of it being private or the immediate transfer. So that's it for a trust. Any questions? Okay. A general durable power of attorney. That's used during life. Once you've passed away, that ceases to have any power. It handles your financial matters. So you'll name someone to step into your shoes. In 2018, North Carolina, the legislature basically redrafted the whole power of attorney, the statutes associated. So now it's a very broadly written document, and it's also a document that has some additional language that makes third parties, which is typically financial institutions, so your Wells Fargo or BB&T or Aquesta, makes them more comfortable using the document. In the past, they really have not liked working with powers of attorney because there's so much fraud associated with those documents. When does it become effective? You can decide. We can say in the document it becomes effective immediately or upon incapacity, or you can activate it in writing or verbally by giving it to the agent. One of those big statutory changes that took place was prior to 2018 for a power of attorney to be active. So for someone to go and act on your behalf with that document, the document had to actually be recorded with the Register of Deeds. And now it doesn't. So they gave that additional comfort to the third parties, to the banks, putting that extra language in there that reduces any liability on their part if someone does fraudulently act with the document. However, to the person who's giving that power, so to you all with a power of attorney, you want to be thoughtful about who you choose because they can take that document and use it right away. And again, it's very broad, so they can step into your shoes and do almost anything. They can't better their own situation technically, but there's a lot of creative ways that can happen. That document also provides for a nomination of a guardian or a conservator. So if something happened and you were in a position that you lacked capacity and someone needed to be named as your guardian or conservator, that document can be used to do that. And then it's also important for assets that aren't owned in the trust. Anything that's in the trust, that successor trustee to you can step in while you're alive, though incapacitated, and act on your behalf. But things that are outside of the trust, they can't handle. So that's then where this document can come into play. And an advanced directive for healthcare. So this, in North Carolina, we have both a healthcare power of attorney and a living will in the same document. In years past, I'm trying to think of when this started, probably 10 years ago. Any documents that are over 10 years old, you have two of them or you don't have a living will at all. And what this document does is, the one I just talked about allows someone to step into your shoes for financial purposes. This allows someone to step into your shoes to make your healthcare decisions when you're not able to do so. It authorizes doctors, hospitals, medical professionals, health insurance companies to speak with someone on your behalf, because we do it with a HIPAA form. And again, do anything for you that needs to be done in regards to your medical care. That's the power of attorney. As I said, embedded in the document is also the living will. That's what makes it the Advanced Healthcare Directive. In the living will is where you make a statement of your end-of-life wishes regarding healthcare. This part of this document takes more time for me to go through than anything else that I go through, because these are really difficult decisions to make. You're presented with 3 conditions that you're in, and you have 3 choices to make. The 3 conditions are: you have a terminal illness that will likely result in your death in 3 to 6 months, and you lack capacity. So we can have a terminal illness but not lack capacity, right? So terminal illness and you lack capacity, someone needs to make your decisions. Or you are in an irreversibly unconscious state or a persistent vegetative state. I don't know if anyone remembers Terry Schiavo from Florida. So it's that situation. Or a substantial irreversible cognitive disabilities. This would be advanced dementia or something like that. Again, irreversible. One of those 3 situations, and you lack capacity. Someone needs to make decisions about life-saving treatment. So you can say in this document, I give my agent the ability to make that decision. So that will be whomever you name. Couples often name each other. Maybe they name adult children, close friends, siblings. Or so give the decision to them, or you'll say right now, withhold life-saving treatment, and you can decide whether or not you want hydration or nutrition. Or do everything you can to save me. I discourage my clients from that simply because we all know that healthcare is really expensive. And if you put in there you want them to do everything they can to save you, that's what's going to happen at all costs. And as I mentioned on the last slide, we do the HIPAA form as well. So this is all in one document, and the HIPAA form then allows the person to get whatever, the agent to get whatever access to information that they need. Any questions on that one? So I just went through the end of life choices. No life-sustaining treatment, but you can decide whether you want food or water, nutrition or water. No life-saving treatment with it, no life-saving treatment without it, or life-saving treatment. Something else commonly used in estate plans is limited liability companies. This can be used where I have somebody who just opened a syrup business. He has a job, he's a day job, but he just opened a syrup business on the side. Or having rental properties is probably the most common one, that somebody just owns one rental property, but it makes the most sense to get it into an LLC, limit your liability to whatever the value is of the asset or assets in that company. And then we have the trust to own. If you have a trust, we have the trust then own that LLC, and it helps to make it far easier to get through transferring the management or ownership of that company after your death, as well as we don't have to take it through probate and have it valued, which I just had Jeff, which can be another cost to probate. I just had Jeff have to value a company for a client. Statement of disposition of tangible personal properties. We talked about that a little bit earlier. That is where, again, I want it handwritten and to say what any items that you want to direct to a specific person or people. Really important to give that message to whomever is coming behind you where you want those to end up. Disabled children. A special needs trust helps or someone who's incapacitated. As I mentioned earlier, if there are any situations where we have government benefits involved, it's really nice to be able to have, if there are extra assets that could come to that person, but we have them protected where they get what they need. We meet all of their needs. However, we don't want to interrupt any of those government benefits that they have in place. The unified credit, as I mentioned earlier, it's over $11 million, $22 million for a couple, over $22 million for a couple. That combines both gifts given during life as well as what passes through the estate after death. So you can give up to that amount, file a gift tax return while you're here, and then it'll just get added to whatever passes to get to this amount. It will come down. It's really high. Like I said, really high right now. We'll probably come back down to the 5 million range, I would think, in 2026. The annual exclusions, and of course, anyone can give $15,000. An individual can give $15,000 to a person. A couple can give $30,000, and then those are not part of your unified credit. Portability between spouses. We can give anything to our spouse when we die, and there's no limit. No estate taxes will be associated. We can also port over their estate tax exemption, so that 11+ million that they have can go over to the surviving spouse and then be used at their death, which could come many years later. We just have to file a tax return in order to preserve that. If we don't file that tax return, it does not get preserved, and they don't get that credit.
I was going to do this from here, yeah.
Okay.
So in terms of financial planning, kind of home runs, everyone probably remembers George Steinbrenner, the former owner of the Yankees. He passed away in a year that there was no estate tax. So I don't know if that was part of his financial plan or not, but worked out really well for his kids. And there was just one year that happened about 10 years ago. So, but some of the other things you can do now, kind of financial planning wise to kind of intersect with your estate plan is make sure that you have accounts set up the correct way. So if we haven't done this with you, we'd like to do this with you. Make sure your accounts are set up so you have your beneficiaries set up correctly. Your primary beneficiaries, maybe a spouse, contingent beneficiaries, maybe kids, friends, relatives, and also make sure those beneficiaries align with your trust documents. That's very important that we have that all working in connection. Some accounts can also be set up as transfer on death accounts. So typically those would be what we call brokerage accounts or brokerage investment accounts. And we'd like to see those avoid probate if they can just be transferred from one spouse to the other, or even generationally if possible. And then in some states, I'm not sure about North Carolina, but bank accounts sometimes can also be set up as transfer on death as well. And that can be helpful in making sure that we're avoiding probate and having assets transfer as smoothly as possible. So that's what we have for today. Would entertain any questions that you have. What do you have, Shannon?
So if you have no beneficiaries, and right now, like currently in my situation, like everything is designated to my estate, but I don't have an estate set up, so then what would I do? It would be...
Kristen, you want to take that one? Maybe you could take that.
Oh, yes.
And the question that Shannon had was in relation to if she doesn't have an estate set up yet, what would happen to her assets if something happened to you? Mm-hmm. Okay.
So that would be an intestate estate. So everything we would open that full estate. We would have an administrator named. We would. Are you married? Do you? Siblings or parents? Siblings or parents is.
No.
Okay. So then that's going to be someone, potentially even someone you don't even know who's going to be named administrator of your estate. All of your assets are going to come into it.
Unless I chose like a really good friend.
Right, but you got to get the plan in place. So we got to get a will in place in order to direct that, because there's no other way to do that without it. Open the estate, file a notice to creditors. There's a 90-day period for creditors to make claims, to bring claims to the courthouse, and then distribute things to your heirs. So you don't have siblings, parents, then we're going to look to grandparents. Nope. Aunts and uncles. And then cousins.
No, I associate with.
Well, they're still going to get it. Whether you associate or not. If we don't have a will, that's what's going to happen. That's where they're going to get. And so, yeah, we have a whole intestate succession. So we go look for kids. Look for a spouse, look for kids, go up to parents, go to siblings, go to grandparents, aunts and uncles, cousins.
And there may be some great charities out there you like. We could set up.
Charities, yeah. I just don't want anyone to be famous. I'm not going to have a lot to give.
And I would encourage you to have a will drafted, because that's where it's going to end up, is with the family and not the charities. Sure.
Logistics question. I was speaking to somebody this weekend, a survivor. They were denied access to the lockbox at the bank, even though their name was on with the person who died. Where do you keep the documents?
So the question Steve had was someone you knew was denied access to a safe deposit box, even though they were named on the account when the deceased died, who was the main person on the account. And then where do you keep your documents if you can't get access to the lockbox? Sure.
So typically when someone's a joint owner, a bank will still let that person in and let them empty the box without someone from the clerk's office being present, from the courthouse being present or having an attorney present. So that sounds like I wonder if they were maybe a deputy on the box rather than a joint owner. So that's a little bit different. The deputy still gets access, but they're not considered an owner.
The safe deposit box is still a reasonable place to put it.
No, but don't put the documents there. No. Never put them in a safe deposit box. For just that reason. For just that reason is the being denied access. Never.
And just a reminder, our wealth management system, you can upload documents. We actually encourage people to upload their estate documents and maybe any sort of directions around their estate as well onto their website, and have family members know to contact us if something happens to them, and we can get them access to those documents. So that's a way of,
I think it's a great idea.
Maybe, getting a little easier access than needing to have a physical key to get in.
So we do need to have the live documents. So to proceed with a will to open an estate or to have that trust, we do need to have the live documents. So I advise to keep them in a firebox or a safe at home. And you always, just like Jeff said, you always want to let somebody know where they are. And I think keeping them with your financial advisor, copies of them with your financial advisor, as well as any instructions that you have with the financial advisor is a great idea, because usually the financial advisor is also going to know where everything is. Another one of the problems in probate is if you have all the documents together, that's great. But if you don't have a list of where your accounts are, they have no idea where to look. So I actually had an estate a couple of years ago that mother passed away. The son thought he knew where everything was. He'd been handling her accounts. We have the estate open for 12 months. We think we're done. We close it. A year or so later, he comes back and says, I found another account. This is not a bad find. It was $250,000. But, I found this account. So now we have to open a whole other estate and go through the whole process again. Fees associated, because we didn't have it the first time. So a list of your assets and absolutely having it with the financial advisor, and the financial advisor knows that this is what we do and this is where we look. And even the accounts you don't have with me, I'll know where to find them. Really important. You don't need balances. You don't need account numbers. Yeah, just know the institution to go to.
Where the accounts are. What type of account and where they are, I think, is the most important thing.
Otherwise, we are actually hunting them down at sending something to every financial institution you can think of to figure out where things are. Recreating from scratch. And to come in and put someone else's puzzle together is really, really hard without some guidance.
Yeah.
Barbara, go ahead.
What if you have a lot of stuff from another state? Trusts and whatever.
You can't tell by Barbara's accent that she's originally from Massachusetts, right?
But she is.
But you have things in Massachusetts still?
I do.
Like accounts or assets or?
No, well, one, but no, mostly just like my will or trust or whatever. I had all that stuff done when I was still living up there.
Sure.
Okay, but you haven't lived in North Carolina. I mean, you lived in North Carolina for a while now. Yeah. You plan on staying here. You just bought a new place.
Right.
So
definitely want to have those reviewed by an attorney in North Carolina to make sure that to make sure, one, that they're doing what you want them to do, and two, that they will comply with our law. So either we're going to research and make sure it complied with the statute at the time it was drafted there, which, we always tend to think it would, but it doesn't sometimes.
No, I already found one mistake in it. So.
There you go. So yeah, that can happen. And so there's a few different ways we can try to get it to work. It usually is better, though, if you've become a resident of another state, to redraft documents in the state that you're in, because then we know it complies with the law there, and it makes, again, a much smoother process. I don't
Janet?
charge to review. I'm happy to look at your documents.
Can you tell us a little bit more about the 404 will and how it might change? You know, if what you have in your trust and you also have additional whatever assets.
Outside of the trust.
Yeah, outside of a trust. Are there any limitations as to what might be included in that 404 will? Like how is that set up?
It's going to catch anything that would go into your estate.
So this is a pour over will that Jenna was asking about, right? What it would do. Okay.
Sorry. Forgot to tell the microphone what we were talking about. So it will catch anything that's going to go to the estate because it's not titled in the trust or it didn't have a proper beneficiary designation. So typically life insurance, IRA, retirement accounts are not going to go into your estate, but there might be some reason that either the beneficiary you've named is no longer alive or able to receive, or there was no beneficiary designated, so it goes into your estate. Or there can be other things that just didn't make it for one reason or another. It could be a car, could be a small checking account that just didn't seem to make sense to take the time to retitle, and then we just need to pour that over. So anything that gets caught into the estate will then get poured into a revocable trust if you have one.
How is it set up? Like how would somebody say, let's say they've already passed on? How does the trustee know that?
How does the trustee know that someone's passed away or what to do?
What's still out there?
What's still out there? How does the trustee know what's going to go into the estate? Oftentimes, not all the time, but oftentimes I have clients they choose to name the executor and the trustee, that successor trustee, that person who comes behind them is the same person. So they're going to go through that formal process of figuring out what is there, having that list of these are my assets. Not even these are my assets in the trust, just this is everything. Then they're going to know, okay, I know this, and this is in the trust, but where's that car titled? Or where's that checking account with Wells Fargo titled? And then they'll figure out, okay, I need to open an estate or I don't need to open an estate. There's ways we can even, for example, we can have a small estate. So something, the first $60,000 of an estate or what could go into an estate automatically goes to a spouse. And then when we get above $60,000, if we just have 60 to 80,000, we can open a small estate, which is 1 or 2 pieces of paper filed with the clerk's office and we're done. So if it's just a car, maybe, and a small checking account, it still is and everything else is in the trust, that's still a pretty easy process.
Okay.
Does that make sense? Okay.
The will would need to have language, right, to say that their assets
Go into my trust. Yes. Yes, the will has specific language the pour over will has specific language that says, pour it into my trust. We don't actually have pour it. We should use that language.
I have a question on vehicle leases.
Yes.
My wife is a self-employed real estate agent. She leases her vehicles, they're in her name. What if she passes during the term of that vehicle lease? Do I assume that debt? Does that debt go away or what happens?
So the question is about vehicle leases and what happens when the lessee passes away and there's no other joint person on there on that contract with them. The contract itself is going to provide for what happens. So somewhere buried in that really small print of that like 3-foot long document they give you, it will say what happens. Typically though, you could just give the car back. So in North Carolina, for the most part, a spouse is not liable for the spouse's debt unless it's joint. You've, for some reason, indicated you're going to pay it, or necessities such as medical care. Those are the things that a spouse can be liable for. Typically outside of those, you're not liable for any of the spouse's debt. And then North Carolina's most healthcare providers in North Carolina are pretty generous even about the healthcare and don't seek recovery from that either. So often a spouse is off the hook. But certainly the contract will provide for that. Mm-hmm.
I don't have a question. How often do you recommend we revisit our plans?
Great question. Every 5 years, I personally do not charge to do that, so I would never want that to be an obstacle to someone, for someone to not have their plan looked at again. It's important to make sure that there aren't any statutes that have changed that'll impact your documents, as well as it's still doing what you want. All those beneficiaries are still there. You still want them to get whatever it is we've designated for them to get.
Second question is, how do we effectively educate the children?
That's a tough one.
About your estate, what your estate is, what your plan is.
Yeah.
What about
How do you educate your children? Good question.
I think it's very important to let them know that you've drafted documents and where they are. It's up to you whether or not they know if they're named in the documents, either as beneficiaries or if they have any fiduciary roles, if you've named them as your executor or as your power of attorney. Completely up to you whether you let them know that. And I wouldn't say that I even have most fall on one side or the other of that. I think it depends on the age of the children, the responsibility level, the relationship the parents have with the children, whether they let them know. But certainly letting whoever you name as your fiduciary, so whether it be the adult children or friends or siblings, but anyone beyond your spouse, definitely let them know where the documents are, because they're not going to know that you keep a firebox under your bed.
I'll give you my personal opinion on that, Lionel. I think it's good to share as much as you're comfortable sharing, and tell them as much as you can. I think it's good to have that conversation while you can have the conversation with them, and explain what your intentions are.
Well, that's what I do.
I like for
If you
people.
have a shady kid, you don't want to tell them.
Right, so that's why I say it all depends on the relationship. Yes. We got nothing, no assets. Yeah. And I think it's important to, if there's anything out of the ordinary, I think I like for people to leave some letter of direction or explanation. So if there's some reason that you've left 75% of your assets to one kid and 25% to another, maybe leave something that says, here's why. You won the lottery and the other one didn't, or whatever the reason might be. Just so that it just makes it easier on the back end.
Is there a time when you recommend being an institution to take care of things versus a family member or particularly a child, especially when you have 3 kids, maybe you don't want being favorite?
So you're saying, like, in relation to naming a trustee, whether you'd want an institution versus a family member, when would be a good time? Yeah.
When is it more beneficial being an institution?
Right. I think you have to first certainly have enough assets to have that make sense, because, as I said, you're looking at probably for the first $1 million around $4,000 a year for them to manage, and then obviously more as.
Like a reasonable amount to avoid fighting.
Sure. Yep. So I really think it's. I'm sure it's not a personal question. That's what I was going to say. On the front end, you think, oh, look, everything's going so well. Everyone agrees and they all know what's going to happen, and then the person passes away and all that's out the window. Yeah, for sure. I think, though, it's very situational. I think it really depends on your kid. If it's going to be children, and maybe it's the middle kid who you think is going to be the most responsible, but then you don't want to tick off the older one, right? I think it really depends on the situation and the amount of assets that they're going to be managing. I, though, have had plenty of clients that have named a younger child, not automatically naming that older one. And again, I encourage that leaving of the letter that, look, he was a finance major, or, it just made sense, something to say, I trusted you. I just kind of thought this was better in his hands. So I think that's so helpful, though. I really do think that's really helpful to give some direction or some explanation on the back end.
Yeah, just to add, in terms of your estate documents, having some sort of informal letter of instruction, I think is just a fantastic idea.
Yeah.
And if you haven't done that, I would add that to the more formal documents that Kristen will really help you with. But just writing things out and just saying, I intend this to go here, this to go there, and explaining as many things as you can. It's just going to help your family get along better after you're gone.
Right.
That's really the idea.
And especially when we're dealing with, if there's things going to young children or to grandchildren, this is what I envision. I'm leaving 30% of my estate to my grandchildren, and I would like for this to pay for their college or their first wedding or their car or what have you. This is what I would envision or what I would have helped with if I was here. Doesn't mean that the trustee has to abide by it, but it just helps give some direction as to what you would have liked to have seen happen with your assets if you had been here to make these decisions.
Yeah. Weird question. You see in the news every so often a wealthy or famous person passes. They have a will, but the family contests the will. How does that happen if there's a will?
Right. So I often include in my will the language that says you can't contest it. And if you do, you're automatically going to be barred from recovering anything. Even if we threw out the will, you're not going to then step in as an heir. However, there are certainly situations that can happen. Every state has different statutes or common law that governs how the wills are viewed or interpreted or what language makes sense or governs. There can be a variety of reasons also that you can get it thrown out. So it can be that there was duress when this really wealthy person drafted this document. They were 92 and they were married to someone who was 26. And all of a sudden now the 5 kids are cut out and everything goes to the 26-year-old. Well, often that's not what we're going to see someone typically have wanted to do. So those would be that would be a reason that it could be thrown out. Or really close to this child, but that child's excluded and everything goes to this other child. So things that it's very situational. What makes sense when we look at the totality of the circumstances often is what a court's going to look at. Would this truly have been what that person had wanted, or were there some fishy things going on there? And a will can also be contested and then thrown out because you said you found a mistake in yours. It could be something like the witness didn't list the city and state that they lived in, and nobody caught it. Or the person did initial page 17 of their will, and nobody caught it, but it had to be. So there can also be little things like that can get it thrown out as well. Will contests, though, typically they aren't successful, but they can be. And those are the ones that we're going to hear about in the news when they're big and they're successful. And then you have people like Prince who doesn't even do one.
You're saying trust that.
Right, it's all private.
It's all done, and it doesn't, so there's no contest.
Exactly, it's all private. A trust is private, so we're not going to have those contests.
If the will provides for a grandchild, just explicitly, then some great grandchildren show up along the way. Do they have equal status, or are they grandchildren, or are they not grandchildren?
So the question is, if a will provides for my grandchild and then the grandchild has children, are we going to follow down that line? So we'll have this conversation. When I draft documents, I have this conversation. Do you want it to stop there with that line that you've chosen? So I'm going to give $10,000 to my grandchildren. Do you want it to stop there? Or if those grandchildren or that grandchild wasn't here to take, so if they passed away, do you want it to go to the next line? So if that grandchild had children, would you want it to go down to them? And that's a choice that you can make. It's called per stirpes. And we just put that language in there that says, this is what would happen. So let's say you had 4 grandchildren and you were going to leave $100,000 to them, but one of them has passed away that leaves 2 children. That $100,000 is still split into fourths. And the 3 surviving grandchildren each get $25,000, and then those 2 great-grandchildren split the share of the deceased grandchild, that $25,000. Make sense?
So that first piece is set up that way that it will drop down?
Yes. Yes. Yes, the per stirpes will follow all the way down the line as far as it can.
How about if the grandchild is no longer alive, but there are no great-grandchildren, but there's a spouse of that grandchild?
We'd have to specifically include that spouse. I rarely have clients do that, but we would have to specifically include that spouse as them.
By name or just say spouse?
We would talk it through. Yeah, we would talk it through whether we would do by name or not. And again, it's very situational. And we can. There are certain things we have to include certain language that has to be there, but we can also get specific to what someone wants to have happen. So just like that, naming that spouse or not. And I did have one recently where they had several siblings, they didn't have children, but they had several siblings they wanted to include. Some of them they wanted to include the spouses, and some of them they didn't. So we just wrote it out for every single sibling and who they wanted to include behind that sibling if the sibling passed. So we can get really specific.
The same line, if the spouse was not thought about or considered in first thirties, can the other survivors just be nice people and include the spouse, or?
Sure.
Because it's
Yes.
not provided?
Right.
So your
if
question,
we
Steve,
had-
was could you include a spouse even though they weren't necessarily included in the will?
Could the beneficiaries?
Could be a challenge with for the beneficiaries to include the spouse.
Yes, they would renounce some portion of, or whatever they wanted to renounce, some portion of their interest in favor of that spouse, if the spouse wasn't provided for in the document. Yes. Any other questions?
You provided their contact information?
Yes.
Wait, that's right on cue. There you go.
And your email is that as well?
There we go. Perfect.
You can email us out, Jeff?
Yeah, we're gonna email this out.
Email this out.
Yes, we cannot.
Yes, we are going to email this presentation to at least 15 different states.